Item number 111, CEP FY 2018-00638, Venanti and Gerson. Officer Shanna Sanders, and that's for property 1220 Northeast 137th Terrace. Item number 111.
Garson Guerriere, owner.
Have you been made aware of the violation?
Yes, sir.
Are there any objections to the violation?
Yes.
All right. Officer?
Shanna Sanders, City of North Miami, Code Compliance Officer. This is a new case that was opened September 7, 2018. Several letters were sent out to the property owner regarding the vehicles that were parked on the front lawn. As of this morning, I drove by real quickly. Vehicles still remain on the property. I'll let the property owner explain why the vehicles are still being parked there.
I was here for the same situation about a year and a half ago. It's actually not lawn. It's actually it's gravel, but it's just the weed that overgrown a little bit, and they dismissed it last year because they said I was grandfathered in because it's been just like that for over 15 years.
I have pictures of the violation if you would like to see.
Sure, Miss.
He just met me in the back this morning and explained that to me. I asked him, did he have any documentation or anything stating that it was grandfathered in. I looked in the computer. I didn't see anything of that nature. So, again, I do have pictures if you would like to see the area that we're referencing to.
Yes.
As you see, looking at the pictures, he has two driveways on both sides of the property. It's a duplex. He has, again, two driveways on both sides of the property, but also tends to park on the front lawn. There is some signs of gravel being there, but it's not a driveway of any nature.
Yeah, the driveway is where the carport is.
Yes.
Where the garbage can is.
And there's two on each side.
Right. So that's where the cars have to park. All right?
But the thing is, we have multiple cars at the house. And it been that way for over 15 years. And the
Excuse
last
me?
time, it been this way for over 15 years. The last time I was here for the same situation, it was dismissed.
I don't see a condition of grandfathering in anything. That's never been a driveway. It's not a driveway today, nor has it ever been a driveway.
And that's what I explained
I
to
can tell
him.
for the construction of it. It's never been a driveway. All right? Find out a violation does exist is cited. Issue an abatement date of March 13th. If not abated by March 13th, then it's $250 per day until abated.
So basically,
You have
so
two driveways. You got to park on the driveways. Or you got to make a driveway for it all. But that gravel is nowhere near, that gravel condition is nowhere near code. All right?
So technically, I got to do the driveway over. So that's what.
If you want to park where you currently have gravel and grass, because even that gravel is not sufficient for the code. So if you want to park there, then you need to make it a proper parking space. All right? All right. Thank you. That's it.
Item number 117, CEFAW 2018-00272, Yolene Auguste, Officer Wayne Clark, and that's item number 117.
Good morning, Code Officer Wayne Clark, Code Compliance. This case is in compliance as of today.
Great.
I don't have to-
All right. Case dismissed.
However, we were told to ask for the fines to go back to the date of the reinspection date, of the reinspection date itself, if it wasn't complied by then to the date, to find the person in violation. From the time of the original reinspection date to today. That was the request that we were told to ask for going forward.
Did I originally adjudicate them?
No.
So this would have been the first time I was adjudicating.
Yes.
Denied.
Okay. Thank you, sir.
Items number 2 through 5.
It's not a money-making.
Item number 2, CEGMP 2018-00320. Item number 3, CEGMS 2018-00052. Item number 4, CEGMS 2018-00054. And item number 5, CEP KL 2018-00001 for property 14295 RC Properties LLC. Officer Karen Jean Lewis. And that's items number 2 through 5.
Person still not here? Oh. Go ahead and make your appearance for the record.
How you doing, Dietrich Val?
What's your relation?
He wasn't sworn in.
Okay.
Raise your right hand. Do you swear or affirm that the testimony you're about to give in these proceedings will be the truth, the whole truth?
Mm-hmm.
Your right hand.
Mhm.
The truth, the whole truth, and nothing but the truth, just say I do.
I do.
And you should say, if so, say I do.
If so, say I
Because otherwise you're instructing them to say, I do.
do. Got you.
These were previously adjudicated. What's your relationship to RC Properties?
The owner.
Okay. It's a single member LLC?
Excuse me?
It's a single member LLC?
No, double partnership with my partner.
You're the managing member?
Yes.
Okay. We previously adjudicated these violations. So have they come into compliance?
I'm just getting a whiff of this, but I object to some of these.
They've
Here's-
already been found guilty. These were heard before today, and they've already been found
When were
guilty.
they heard? I just purchased the property.
Oh, well, then you should have known. When
Well,
you mean you just purchased the property?
I purchased it about 6 months ago.
Good morning, Co-Compliance Officer Karen Jean Lewis. This case was heard on January 22nd, 2019.
Okay.
And I just got notice of this. I never received notice of this prior to the prior. And before I purchased the property, though, here's what I need to get out,
Okay.
if I can.
Sure.
Before I purchased the property is in disrepair. I went to a guy by the name of Steve Pizzillo. I was told to talk to him. He works in somewhere in the city. I forget his title, but I sent him an email. I met with him. I could read you the email if you want. Just to summarize the email, I asked him, and I put it in an email writing that, hey, I don't want to purchase this property if it needs a 40-year inspection. Okay, I don't want to purchase this property. It's in disrepair. If there are problems with this property, let me know now. Let me walk away. Let me just take my money and walk away from the table. I have emails.
Did you do a lien search report?
Yeah, I had a lien search. It was they cleared all the liens for whatever, I don't know. All the liens, I bought the property without any encumbrances. No liens on it, clean, no cloudy liens, nothing like that. I didn't write as is, anything like that.
And no open violations at that time?
No open violations at that time.
And,
Now I buy the property,
uh-huh.
and they come back to me and say, here's all these violations. It doesn't need a 40-year inspection, but everything that a 40-year inspection entails, you need to do. Which, okay, either it doesn't or it does. And I have emails saying that it didn't. So I told him it was going to cause me tremendous financial harm if I purchased this property. And I don't want to go there, but I think I have standing to say that, you know, I don't know if I was dealt with in good faith.
Okay, so the violations were to pressure clean and paint the entire property,
Which is a 40-year inspection thing,
repair or replace the damaged carport covers,
which is a 40-year inspection thing.
obtain all necessary permits from the building department and repair the damaged ceiling.
The business has been operating there for the last 20 years. So why, when there's a new owner,
Please make sure there is adequate lighting throughout the premises.
been operating this like this for the past 20 years, so why, when there's a new owner, I specifically went, he didn't even want to answer my email. I had to get help
Did you
from the
obtain
city
the
manager's office
Did you obtain
in
the
order to
certi-
force him to answer the email.
Did you obtain a certificate of use prior to the closing?
The property that I didn't obtain, I'm not in the business. I'm a landlord. So the business has been operating there for the past 15, 20
Did
years.
you go through a realtor?
Yes, I went through a realtor. I had a formal closing, a title company,
All right,
et
so
cetera.
a realtor would have known that in the city of North Miami, all new owners must obtain a certificate of use prior to the closing. And if you would have applied for the certificate of use, an inspector would have come out, and an inspector would have told you that all these things existed,
Okay,
and
but
that you would not be able to get the certificate of use because these things existed.
here's the issue. The business
Excuse
has
me,
been in
Can I
business.
interject a minute? It's on?
Yeah.
Good morning, Gary Beswick for City of North Miami. So some clarification. For business, I'm aware of the email he's referring to. But the violation that you were cited for really have nothing to do with the 40-year.
Nothing to do with what?
The 40-year recertification.
Okay.
What the magistrate is referring to does not apply to a business. I'm familiar with the business you talk about. Don't apply to residential business for the reoccupancy certificate with title transfer.
Right.
The business, the tenant do need a certificate of use permit, and if my memory serves me well, when I went there for that inspection, there was some issue with Durham. I'm not sure if that was clarified, but
It was
I didn't
clarified.
pass the inspection when I went, so I'm not sure if that
Okay.
was clarified. So the violation that she cited you for have nothing to do with the 40 years. So we'll clarify that. Those items that she cited you for.
Well, okay, so it's kind of like, okay, the 40-year inspection includes this, that, and that. You don't need a 40-year inspection, but item number one that a 40-year inspection entails, you need to do it. If I don't need a 40-year inspection, then all the items that are included in a 40-year inspection should be waived.
All these items can be separately cited without their needing a 40-year.
That's
In
correct.
and of themselves, they are violations of the code outside of a 40-year
Correct.
research.
Okay. Okay.
That's why they cited you, because that's why they can say this is not about a 40-year research. All these issues are citable outside of 40-year research situation.
I understand that,
Okay.
but
And the need for the certificate of use probably prompted an inspection, which prompted them to go out.
well, you know, I understand that, but with these emails floating around that I do have, you know, and I'm sure they're
But
around.
They're saying that when you sent the email, that a 40-year research was not necessary.
Okay.
A tenant needed a certificate of use.
Well, let's not talk about the certificate of use. Let's talk about everything else.
The certificate of use prompted the inspection that caused the other violations to be cited.
Okay, but if I don't need a 40-year inspection, then why do I need to repaint the building if I
Because-
don't need a 40-year
Because
inspection?
buildings have to be painted in the city of North Miami. They can't just be, oh, this is not a 40-year research situation, so I can't make you paint the building. That's not how it works. They can make you paint the building regardless of whether there's a 40-year research or not. It's part of the code. The
Okay.
code doesn't require a 40-year research to make the property owners paint the buildings in North Miami. It's a separate code issue.
So when they say it doesn't need a 40-year recertification,
It didn't.
okay, but they're
I'm
gonna.
assuming it did.
Okay, they're saying.
That's the building department.
Yeah, I'm assuming it
they're
did.
saying
I'm
it- the-
assuming that they were truthful with you, that it did not need a 40-year reinspection. And what I'm telling you and what they seem to be saying, this is what I'm hearing from them, is that a certificate of use was applied for, which prompted a code enforcement person to go out to the building. When that person went out to the building, they saw these other violations and cited you because the violations were independent violations of code, not 40-year recert violations. They were independent violations of code.
Okay, which just so happen to be some of the items that it takes.
Well, there's a
to
lot
do
of
a
stuff.
full-
There's a lot of stuff that goes into a 40-year
understand-
recert.
But you understand what I'm saying?
There's a lot of things that go into a 40-year recert. But just because those items may be included in a 40-year recert doesn't mean that they are not independent violations of code, independent from a 40-year recert. Now, if your inquiry to the city was, do I need a 40-year recert? And they tell you no, and they're still not asking for a 40-year recert, but someone goes to the property and sees these independent violations, yes, you can be cited for these independent violations.
Okay, you don't think that? I mean, well, I mean,
But
I just want to say that's kind of like well, yeah, you don't need it, but you do need it. So if I didn't need a 40-year recert, but I have to do the things that require that are involved in the 40-year recert.
you know, there's a
then-
lot more than these things that are involved in the 40-year
I understand that. I understand that, but it should have been like, well, you don't need a 40-year recert, but you need to still do. There's certain things in code compliance that you need to adhere to.
You wanted them to go out and inspect it before you bought it.
I just have emails saying that, yeah, go ahead, you're not gonna have a problem.
You asked them for a 40-year. I'm assuming. Again, I'm not privy to any of this
No,
stuff.
of course.
But I'm assuming that you asked them about a 40-year recert, and that their answer was specific to what you asked them about,
Yeah.
and that there was no inspection of the property at the time that you
But
asked them about. Let me.
Go ahead.
And I'm assuming that there was no inspection done at the time that you asked them about the 40-year recert, because a 40-year recert is just based on the age of the building. So they can go and look at the age of the building and say, no, there's no 40-year recert.
I got you, but you know it's
necessary.
misleading. It's misleading.
Huh?
It's misleading. It's very, very extremely misleading.
I don't think you asked the right question.
Well, I mean, see, that's why we have people like you to decide and a system and order and courts.
But as
You
I
know?
said before,
I think it's misleading.
this matter was already, these 4 matters had already come before me, and had already made a decision as to these 4 matters, that these were in fact violations of code and that they needed to be
I never
rectified.
was here to even defend it or talk about it or anything. I never got any notice from anyone.
Notice was sent to whatever address existed at the property appraiser's office and posted at the property.
not the owner, but the tenant didn't give me this till after that was done.
But the way they delivered notice was proper. We can't account for what your tenant may have done. Because
The
it was,
tenant may have done. So there were other issues before I bought it. I think some of these issues appeared before I bought it, and then they were wiped away, and then I bought it, and then they reappear. So I don't know what's going on.
I don't know either.
But I can show you that. If I can show that to you.
If you show me that you asked about a 40-year recert,
No, I can show you that. We're not talking about that because clearly I was misled. I feel I was misled. That's a matter of opinion. But that some of these issues existed. I don't even think you were on this property. I think you just got reassigned to this property in the last 6 months.
The violations were observed on the property September 21st, 2018.
2018. So I bought it in around June. Okay. When did you start doing this property? When did you start this? When was this property included in your area? Probably after I bought it.
Well, I'm not sure what date you purchased it.
Yeah,
I
probably
want to
purchased
say
it like in June.
I want to say I was reassigned to the northwest side June 1st.
Okay, so I bought it in June. There were some of these issues, they were wiped away.
What do you mean they were wiped away?
When I was buying the property, I had to sue him to buy the property because he tried to go up on the price because there were a plethora of code violations and it was gonna cost him money to fix.
So you were aware that there were code violations at the
But
time
he had
that you
to,
were buying the property?
yeah, he had to fix them.
Okay.
In order to close, he had to give me the property without any liens or any code violations on them.
Okay.
Somehow they were fixed. I didn't ask any questions. I went to the closing table. There were no liens. All of these liens they disappeared. And now I buy the property. They reassign the code compliance officer, and now all these things appear again. I can show that.
All right, show me.
Okay, I mean, not now, but I can reschedule with you and show you. Yeah.
Counsel?
Judge, may I?
Yes.
Shayla Vasquez, Assistant City Attorney. At the end of the day, once this gentleman took over the property, he is responsible for all of the codes that come up, whether they're part of a 40-year inspection or not. He's responsible for them, whether they disappear and come back. He's in possession of that property. He's a home owner, home manager of that property. He is responsible for making all of those things come into compliance. I don't see any further discussion regarding that matter.
Well, let me paint the picture for you. He's saying he was in a real estate transaction involving this property.
Correct.
At some point during this transaction, he was made aware that there existed some code violations of the property. This was brought to the seller's attention. Pursuant to their contract, the seller had to cure it in order to close. The seller then provided him, I'm assuming in writing, so some instrument, that those violations had indeed been corrected and were no longer an issue with the city. I'm also assuming that he did a lien search report and that the lien search report came back clear. And a lien search report basically says it's an inquiry into all the governing municipal agencies as to what liens or permits may be or violations may be existing on the property at the time of the intended sale.
And it's also his responsibility to check that that was complied with, that was done.
Right.
And clearly it wasn't, because he's had it for 6 months,
Well,
and in January.
Counsel, let me finish my picture. And so what he's saying is that he received a clear on his lien search report. He received something from the seller saying that these issues had been cleared. He then closed, and after closing, that the very issues that may have existed prior to him closing are now being cited for again with a new code compliance officer.
I haven't heard of any proof throughout this whole hearing, let's say, that those are the same exact violations.
And that's
all
why
of them.
he's asking for additional time to show that. That was his last remark before council asked to speak.
And what happened at the last hearing on
No one
January
appeared.
16th?
No one appeared. It was adjudicated. It was adjudicated in absentia because no one appeared.
So is it his contention that he didn't know for the past 6 months that these violations occurred?
That's been his contention from the beginning.
Don't you want to get to the truth? Don't you want to get to the truth?
That sounds like the truth to me, sir.
Well, don't you want to get to the truth?
That sounds like the
If I
truth
can
to
show
me.
that, that'd be a different story, right?
That sounds like the truth to
I'm
me.
asking you a question. If I can show that, that'd be a different story, right? Yes or no?
I haven't seen anything, sir.
Okay, but if I can show that, that'd be a different story, right?
Where is it?
Case
Okay,
reset
let me
to
go
March
find
20th.
it, and I'll show it to you.
Out of the 5 cases, CEGMP 2018-00320, there's no adjudication, and that was to pressure clean and paint the entire
So
property.
there's no adjudication.
No.
I show that it's been adjudicated. It was adjudicated.
There's nothing on here that says that it was, but okay.
All right, March 20th.
All right, thank you.
That they were previously medicated?
Item number 109, CEJNK 2018-00214, Therese Balthazar. Officer Ernst Baptiste, and that's item number 109.
Did you sign in up here? Go ahead and make your appearance for the record.
Jesse Antoine, 3 Spartans son.
Ernst Baptist, City North Miami Code Enforcement Officer. This is a case that was open for mattress and other items stored under the cardboard. Open my re-inspection. Case is in compliance.
Case dismissed. Just for the benefit of the clerk, that case was dismissed.
Item number 38, CEIVY 2018-00355, Edwin Morno,
Go ahead and make your appearance for the
Ernst
record.
Baptiste.
Go ahead and make your appearance.
Edwin
Your name?
Warner is my father, and Micheline is my mother. She's deceased, 2015. I'm in probate right now to inherit the property. Mr. Baptiste.
Your,
My name is Terry Morno.
what is the condition of Edwin Morno?
He's in Haiti. He retired. Going out of the country.
And you're probating and they were married up when she died?
Yeah, they were divorced still.
Oh.
But for some reason, North Miami still got them together. They've been divorced since
It's not
97.
North Miami, it's the county appraiser's office.
So for some reason, they still together. So I just gotta do the paperwork.
Okay, I had already heard this case once before, found it guilty. Is there compliance?
No compliance.
You give me 2 weeks.
All right, March 20th.
Let me get clarification. Which cars?
And have you opened the probate?
Yes.
Have you received the letters?
I did between me and my 2 brothers. Now my brother signing it off. I'm supposed to be doing a quick claim deed and getting it switched over.
You did this with an attorney?
Yes.
All right, ask them for a copy of the order appointing you as the PR and the letters. All right, so you can bring that back next time on March 20th. Just to make sure that you have authority to speak on behalf of the estate.
Which cars exactly you want out of there?
Crashed one that is
In the
inside-
yard?
In
Yeah.
the yard,
The
yes.
2 in the yard?
Yes.
Off the mic, guys.
Yes, sir.
Thanks.
Thank you. You said March 20th?
Yep.
Item number 79, CEFAC 2019-00002, Marlone and Bessie.
No, we must have reached the end.
Officer Jose Perez, and that's item number 79.
So this is this is a citation. This is-
Yes, Judge. Shayla Vasquez, Assistant City Attorney. I'm going to be prosecuting the case, Your Honor.
Yo estaré a cargo de este caso, dice ella.
Mr. Perez put it on last minute
El
for it
señor
to be a hearing because we're
Pérez
going to be going
lo
under
puso.
Section 529C, which we're going to be asking for the max of $15,000
Vamos a
for
pedir
the violation in this case.
$15,000 por la violación.
And that's Chapter 21, Article 3, Division 1. If Your Honor
Ma'am,
would
have you
like
been made aware, make your appearance for the record.
Primero diga su nombre.
Bessie Manueles.
Betsy Manueles.
Okay. And have you been made aware of the nature of this violation?
¿A usted le han informado la naturaleza de esa violación?
No.
No.
So you don't know why you're here?
Entonces no sabe por qué razón está aquí.
Estoy supuestamente lo que me dijo José por lo del
Supposedly, I'm here because of the gas that was broken
And the way that it was broken.
y en la forma en que fue rota. Yes.
So what the city is going to be attempting to show is that there was work being done on your property without a permit.
Lo que la sociedad va a tratar de probar es que se estaba haciendo trabajo en su propiedad sin permiso.
Which led to the breaking of the gas line.
Y eso, por ese trabajo, rompieron la línea de gas.
Do you
Okay.
disagree with their position on this?
¿Está en desacuerdo con la posición de ellos?
Sí, porque es demasiado dinero.
Yes, because it's a lot of money.
And
Not
Judge, I-
about, not about the money. I'm not talking about the money. I'm asking, do you disagree with how this gas line on your property was broken?
No estoy hablando del dinero, dice. Usted está en desacuerdo en cómo esta línea de gas fue rota, en eso solamente, no el dinero. ¿Está en desacuerdo o no está en desacuerdo? I do not. I agree.
Okay. So she is admitted to the violation.
is that correct? Did he
Yeah,
translate
she-
that properly?
She agrees with the violation. She does not disagree the violation.
Okay. That's fine. We still need to have a hearing for the 15th, for Your Honor to be able to impose the $15,000.
Bueno, está pidiendo la
Okay.
sociedad que le
If not, you can
le
ask
ponga
for the ruling, and then the
un-
city can just provide Your Honor
una
with
multa de 15,000
the
dólares.
photographs, the BWC.
Si no, nosotros podemos proporcionar
Well, she's
fotografías.
admitted, you guys made it an allegation. She's admitted to the allegation. What else do I have to do?
Well, we're asking for.
I mean, except for rule that
Están pidiendo que yo
the
haga
violation does exist as cited.
I would like Your Honor to review the evidence,
necesita que usted revise
so we can
la
properly,
evidencia
if for any reason this gets appealed,
Para-
everything is on the record and everything is
para
entered.
que todo esté en el
What's there
acta.
to, who's gonna appeal it?
Un segundito. Le va a tocar.
She admitted to the violation. Then what's there to appeal?
Judge, I want to make sure that she's aware that she's admitting and that there's that's a
The
possibility
fine,
that.
the punishment never has anything to do
Bueno, el castigo no
with the
tiene
nature of the violation.
nada que ver con la
If the
forma
violation
que se
exists, the
hizo la
punishment
violación.
is what the punishment is.
La
The question
violación
is,
es una cosa, pero el
did the
castigo-
violation exist? And
Sí,
she's
sí.
admitted that
La
the
violación.
violation exists and
Ella ha
occurred
admitido que la
as the
violación
city has
existió.
alleged in their citation.
Yes, Judge.
Okay. Correct.
Correcto.
You must,
Tiene que decir en palabras, ¿sí o no?
Sí.
Yes.
okay. So what now? So
Okay.
I find
Bueno,
that
mi
the
fa-
violation
mi falla
is
es
correct
que
and
la
has been admitted to.
violación es correcta y ella es
She also
admite
paid
eso.
for the ticket, Judge, so admitting guilt in this case.
Right. So
Ella
we have
está admitiendo
multiple admissions of guilt.
Yes.
culpabilidad.
What do we do now?
¿Y qué es lo próximo que
Well, under 5-29, the city is going to be asking
Bueno.
for the max that Your Honor can
Vamos-
impose.
Vamos a pedir
In this case,
lo máximo en este
Why is
caso.
the city asking for the max?
¿Por qué está
yes,
pidiendo
Judge.
el máximo?
There's several things we'd like to
Hay
enter into evidence so
muchas
Your Honor can
cosas
see
que
why. First, I'm going to
nosotros-
go ahead and start with the photographs if I may
Primero, yo
approach.
quiero
All
mostrar
right,
las
so
fotografías.
these are the mitigating and aggravating factors.
Yes, Your Honor.
All right.
The first set of photographs are
primeras
the photographs that
fotografías
were taken the day that the
fueron
violation
tomadas
actually
el día
occurred,
en
which
que la
shows,
violación sucedió
if Your Honor sees there, the gas leak
y se ve el día de
rupture that
gas
occurred on the property
que
due
sucedió en la
to
propiedad.
the violation of 5-32, which is that the homeowner was installing a fence without a permit. The second set of photographs were taken by Mr. Perez yesterday, and they are photographs of the homeowner actually still, after this, everything occurred, installing
Todo esto,
um,
ella todavía está
the fence on the
instalando
property without having a permit.
sin
There
permiso.
is also an incident report that was
También
authored by
un
Officer
Reporte de incidente
Josham, who's here present today.
está en la oficina está aquí.
She was present that day and
presente ese día.
appeared on the scene with Officer Antoine.
Sa-
um,
San Juan,
The fire department had to show
y
up.
también los
It
bomberos
was,
llegaron,
it was a pretty big deal. I'll
y fue un
pass up
caso
the incident report if I may.
bastante grande.
And read for me the applicable statute for which you're relying on for the maximum. in-
Yes, Your Honor, that
La
is,
razón por qué usted está está pidiendo la máxima penalidad.
I can pass it up as well. It's Chapter 21, Article 3, Division 1, Section 2120.
Con las leyes
If the special
del
magistrate
artículo
finds a violation to be irreparable or irreversible in nature, it may impose a fine not to exceed $15,000 per violation. In determining the amount of the fine, the special magistrate shall consider the following factors. Number 1, the gravity of the violation. Number 2, any actions taken by the violator to correct the violation. And number 3, any previous violations committed by the violator. I can go ahead and elaborate on
Yo creo que
1, 2, and 3 for Your Honor as
he
well.
hablado ya de los
Go back to the
números.
beginning of it.
If the special magistrate finds
Mhm.
the violation to be irreparable or irreversible in nature.
Se
Stop.
piensa que esta
Yes.
violación es irreparable, entonces
How is
debería
this
aplicar la máxima.
Irreversible or irreparable?
Que es-
It was,
Yes.
it was in fact
que no se
repaired,
puede
correct?
reparar y que es
Judge, it ended
irreversible.
up being repaired after a lot that happened that day, and if I may, I'd like
But
to
it-
show you
But
the,
it was in fact repaired,
Pero ha sido reparado.
thus making it not.
Entonces, eso
Irreparable.
no lo hace algo
but that
que
is
no se puede
after the
reparar.
fact, Judge.
Pero
There
eso fue
was,
después.
because of this work that was done without a
Entonces,
permit,
por el trabajo que se hacía sin
there
permiso,
literally was gas, you could smell the gas and the officer can
se
testify
podía
to that.
I'm-
explicar, oye,
From down the
se
street,
puede-
this
ah,
whole
podía
block
oler
could have
el
been
gas
blown
y
up.
la
It
oficina
could
de
have
la
been,
policía puede testificar
but it
sobre
wasn't.
eso. Entiendo eso, díselo, pues.
And it was reversible
Y
and repairable,
usted-
and it was
eso
thus
fue, entonces,
repaired,
fue
thus
reversible
not
y
making
fue
it
reparable.
irreversible or
Entonces,
unreparable.
eso no es
But
algo
by the
que es
time that they
It was
already,
a big deal.
irreversible.
We
Eso
get
no-
it. It
eso
was
no
a
es-
big deal. But it was not irreparable nor
es un
irreversible.
caso,
Judge,
So
our cont-
therefore,
pero
I
no
find
es
that the
algo
statute
irreparable.
that you're attempting to use in this regard is inapplicable because I am not finding that it was irreparable or reversible
Si
or
fuese
irreversible.
irreparable
and Your
y
Honor, our contention
irreversible,
is that by the time that this had already occurred,
cuando esto sucedió,
there was no way to fix it.
no había forma de
We had, they
arreglarlo.
had to hire other contractors to come on the property and actually deal with this. The fire department had to come out. The whole road had to be blocked off.
Todo
At that
el-
point, it
la
was
calle ha tenido que ser bloqueada.
like, it was irreversible because it had already occurred. It was already done.
From what you've read of the statute,
Bueno, usted ha leído el
it
estatuto.
appears that from the plain meaning of the language of the statute, that the harm itself
Dice,
has to be
el hecho
irreparable
tiene que ser
or
irreparable
irreversible.
o
Period. Is there a period?
o irreemplazable.
No, it was a comma, actually.
What's the and what's after the comma?
It may
Sido-
impose a
sido
fine not
nuevamente
to exceed
irreparable.
$15,000 per violation.
Estamos
Okay,
pidiendo que
so
se
the beginning thought is that
Bueno,
the
para
harm
empezar,
itself has to be irreparable or irreversible,
ha sido irreparable o
and that was
irreversible,
not the case here.
pero ese no es el caso.
Even though it had already
Aún
occurred, there's
Ah,
no
ya
way of
sucedió.
fixing the gas emanating in the air, Your Honor.
Because
forma.
what happens when the gas goes into the air? What happens eventually?
Anything could have happened.
It dissipates.
Bueno, el gas
That's
If
what
it's
happens.
if it doesn't set on fire because someone's smoking a cigarette or
But
there's
we
something
can't-
nearby.
We can't punish her for what could have happened. We can only punish her for what did
solamente
happen.
podemos especular, podría.
Okay? If we punished everybody for what could have happened,
Nosotros
this would be a very
castigamos a la
different
gente por las
society.
cosas que podrían
Is Your
haber
Honor willing
pasado.
to watch the body-worn camera of what actually occurred that day?
You can show it to me,
Usted me puede mostrar.
but it's not going to change my
Pero
opinion as
no va
to
a
whether the
cambiar mi
harm
opinión
is
acerca
irreparable
del daño
or
que sí
irreversible.
ha sido irreemplazable
Okay, I'd like to show
o
it to you.
Okay.
inarreglable.
And Judge, while that's setting up, I'd like to refer to Chapter 21, Article 1, Section 21-4, which is the definition. Under, it states uncorrectable violation means a violation which is irreparable or irreversible in nature, and which cannot be remedied after the violation has been committed because the violation constitutes a single prohibited act rather than an ongoing condition or circumstance. So what we're
did-
trying to,
That didn't help you.
I'm sorry?
That didn't help you.
Judge, I believe it does. What we're trying to say is that the damage was already done. By the time that everyone
It
came
said-
out,
It says it means that it could not be fixed. Read it again to me.
Eso es.
Cannot be remedied after the violation has been committed,
But
and
in
that's
fact
exactly
it-
what
but
happened.
in fact, it was remedied after it,
Pero
the
el hecho
violation
de que fue
was committed.
arreglado después.
Otherwise, we still have we still have gas
Si
pouring
no,
out of that
en este
particular
momento todavía tendríamos
area.
ese líquido de
So it
gas.
was in fact
Pero
fixed
fue
after it
arreglado.
occurred.
Eso ha sido arreglado después.
Doesn't say how long.
No
Doesn't
importa.
have.
Ahí no
Doesn't say
dice
how long
cuánto tiempo
it has to
debería
be.
estar.
It says
Dice
that
It's
it
a
couldn't.
s-
It could not have been fixed
que
after it occurred.
no dice
But the
si
fact is, it was in
arreglado
fact
después.
fixed
Pero el hecho
after it
es que
occurred.
fue arreglado
But it also says that it constitutes a single prohibited act, not an ongoing condition or circumstance. So as soon as that gas leak was, that pipe was broken and that gas was emanating in the air,
Si ya se rompió,
that's it.
salió, entonces ese es el hecho. Ya.
I'm not persuaded.
Eso no me
But
convence.
show me the video.
It's on his laptop. Do you mind if he comes up to? Video 1 until 11.
No, le vamos a dar un video. No sé.
Until 11:30.
And let me read the statute, the I'm pausing the video because that person's just driving for right now.
Oh.
But I'm gonna go back here for a moment.
Bueno, voy a
Because I'm reading
Y estoy leyendo.
section 21-20.
Esto está
A.
leyendo el código
And,
que aplica.
and so my question to you is that did the city incur cost in making repairs that day?
Pagó
Did the
para
city
hacer
make the repairs
reparaciones.
that day?
It was an independent, I'll let Officer Perez answer that.
So so the city responded to the incident. At that point, the city contacted the fire department. At that point, the fire department responded, and they contacted private contractor, Florida City and Gas. So the city was the one, in fact, who went to
Constructores
repair the
privados
situation.
para atender.
Right, so did the city incur cost in that?
Entonces, la ciudad,
And do we know what that cost is?
We don't have a dollar amount regarding the cost,
no
Judge.
tenemos
So city gas did, what was it called again? Florida City Gas didn't invoice the city for the repair?
Florida City Gas no le mandó
Did,
una
did we
factura
get
por
an
eso.
invoice? I'm not sure, Judge. I'd have to look
Pero no
into whether
sabe.
we got an invoice or not
Ma'am, you have some
This
insight?
recently.
I'm sorry, Your Honor.
Ma'am, do you have some insight?
Dijeron que el gas el bill me lo iban a mandar a mí.
I was told that I was going to be invoiced for that. For the gas.
So Florida City said that they were going to invoice you?
Florida Gas le iba a mandar la factura? Yes.
I'm going to read the entire section.
Después va a leer todo,
And Judge,
todo
I
eso
can pass up also
para enterarse.
5-29.
También quiero recalcar, dice, un estatuto de esa misma ley que aplica.
Is there a citation?
Yes, Judge.
Let me see the
The
citation.
citation, the CVT was 12789, and after the fact where she still didn't get a permit and still continued to do the work, she was issued a new citation yesterday, and that's CVT 12857.
No, the citation with regards to this particular incident.
This case?
Yes.
Yes, 12789.
Not the one that she got yesterday.
No, yes, correct. This is this case.
Okay, yeah, let me see the citation for
Sure,
this
one
case.
second. May I approach?
Yes. Do you have the actual citation that was issued?
Yes, Your Honor. One second.
Está pidiendo la citación misma, el ticket.
And I'm also passing up the notice, which includes 5-29.
Ya estamos dando los documentos.
So on when did she get this one? When- The day of. So this is this?
No, that one is for building without the permit.
She received on that day as well.
Correct. She received the citation that day for the building without a permit, and she received a notice of violation for the gas rupture.
Printed out like this?
It with a thermal printer, so it's a slim print. But it's the same violation.
So not like this, but like this.
Correct.
Your Honor, in the WC, it also shows the homeowner getting the violation, the ticket from Mr. Perez, where she's laughing at the situation.
Que ella recibió la
You know that
notificación.
this doesn't indicate what subsection.
Está riendo.
This doesn't indicate the subsection.
I'm sorry, I can't see that far. May I?
This, the citation for violation of 5-29 does not indicate the subsection for what she's being cited for. I know you have the wording, you put the wording there. I'm assuming that's the wording. Right.
She was also advised in person, Judge, which is on the
What's the,
camera.
what's the charging document?
A ella se
That
le-
is a charging document, but I
Right.
believe
Se le
if
dijo
that's the
que
notice
pasó.
that Your Honor's holding up, it
Right.
says 5-29.
Right. But 5-29 has 4 subsections to it.
Correct. I mean, if we're on that stage, I thought she already found her, Your Honor already took her admission of guilt as evidence in
Well-
this case,
well,
but
now-
we can
well, now
also
you-
supplement.
Well, now you're giving me a cause to rethink that.
Well, we can go back, Judge, and I'll ask Your Honor to supplement the violation that day, although she received notice in person, although that was provided to her, and we can go ahead and say it's under 5-29C.
Okay. 5-29C.
which I passed up
operating.
for your honor.
That's what and I'm reading it now. No owner, operator, or occupant shall cause any service, facility, equipment, or utility
Yes.
which is required to be
He's in person.
supplied
Let me use
by
this.
the provisions of this division to be removed from, shut off, or discontinued for any occupied dwelling unit except for necessary repairs, alterations, or
Yes.
emergencies.
That's what I'm saying.
Okay.
And if I may, Judge, there's also a photo of the actual violation she received that day, and it's very specific. I can pass that up as well.
Y también
Okay.
tiene una foto de la citación que ella recibió en el mismo día.
So that's the violation. Okay. Do you have, hold on, 21-16 CA, the special measure shall notify Do you have a copy of 21-16C1?
Yes, I do. May I approach?
Yes.
Le está pidiendo una copia de esas reglas que aplican.
So, we find that I found that section 5-29
Bueno, esa sección
C
29
has been violated and so admitted to by the property owner
bueno,
in the paying of the fine and in testimony before me.
está de acuerdo que sí sucedió así.
The city has offered
Y la ciudad está pidiendo
two ordinances for the imposition that a $15,000 fine be levied
está pidiendo
against the
15,000
property owner.
dólares contra
Up to,
la
Judge.
dueña
Your
del
Honor
gobierno.
has the
Hasta
discretion.
15,000, hasta
I thought you wanted $15,000.
That's what I'm asking for, but
Oh.
just to let your
Okay.
Honor know.
Because if you're gonna tell me up to, that's gonna be a whole different story.
That's what I'm asking for,
Oh, okay. So this again,
but I'd like your Honor to be.
the city is requesting the imposition of a $15,000 fine.
hasta un máximo de 15,000.
The city has offered to me section 21-4.
Según las secciones
Excuse me.
4
First, they've offered to me section 21-20 of the city code,
la sección 29, 20.
which states in Part A that a special magistrate, upon notification by the code compliance officer that a previous order of the special magistrate has not been complied with
que,
by the set time.
que si, por ejemplo, no
I'm going to stop here to say that that is not
situación para la fecha.
the nature of this particular case. That's not why we're here. Would that be correct?
En realidad no estamos
Yes,
para
Judge.
esto.
All right.
todavía.
Or upon finding that a repeat violation has been committed.
Sí hubo tal vez una
And there's a particular
repetida.
set of criterion that I must
En este
look at to deem something to be a repeat violation, correct?
tenemos que verlo
Yes.
desde un punto de
Okay,
vista
so
muy
we're not talking
particular.
about a
En
repeat
este caso no
violation
estamos
either,
hablando de
correct?
una repetición de violación.
Not in this case, but she did repeat the violation as she was cited for yesterday.
No, en
Okay,
este
but
caso,
in this case, we're not talking about a repeat violation, right?
pero de este caso no
For the
estamos
same
hablando-
case, yes.
Right.
de este caso no estamos
So,
hablando que, bueno,
It says, again,
No
we
lo
go
hizo
back, it
otra
says,
vez,
or
en
upon
su caso.
finding that a repeat violation has been committed,
entonces,
may order the violator to pay a fine
si hubiese
in an amount
una violación,
specified in this section
ah,
for each day the violation
por
continues
cada día
past the date set by the special magistrate for compliance,
continúa.
which refers back to the first sentence of the subsection, or each day the repeat violation continues, beginning with the date the violation is found to have occurred
Multado
by the code compliance
por el día
officer.
de la celebración. Está leyendo lo que dicen las reglas.
In addition,
Además,
if the violation is a violation described in subsection 21-16C1, which this would have been, and that code states that
el código dice,
special magistrate shall conduct hearings
el
on a
magistrado
regular monthly basis. But if the code compliance officer has reason to believe a violation or the condition causing a violation presents a serious threat to the public health, safety, or
esta
welfare,
violación
or if the
causa
violation is
un peligro
uncorrectable in nature,
y si esta
the code
violación
compliance officer shall make a reasonable effort to notify the violator and may immediately notify the special magistrate and request a hearing.
tiene que,
In this particular
en
instance,
este caso,
based on the testimony that I've heard thus far,
un testimonio,
what the city chose to do
la ciudad
was to,
dijo,
because it was a threat to the public health, safety, or welfare,
una
to correct the violation immediately instead of
Sí,
contacting the
sí.
special magistrate for a
hacer
hearing.
las otras gentes. Ella corrigió,
No,
se
Judge,
cor-
that was,
se
so,
corrigió.
what that's
corrigió
saying
la
is that
violación.
as soon as, and Mr. Perez did, as soon as this
Right,
was
that's-
corrected, because it had to be done, he put it on before Your
Ajá,
Honor
se
immediately.
puede-
No,
se
that's
tuvo
not what
que
it
ser
says.
corregido.
To request a hearing.
It says that, right, it says that if the code compliance officer,
Si el oficial,
Mr. Perez,
el señor Pérez,
has reason to believe a violation or condition causing the violation presents a serious threat to public health, safety, or welfare, which it did,
para la salud.
or if the violation is incorrectable in nature,
La violación es- no
the
se
code
puede
compliance officer shall make a reasonable effort to notify the violator, which he did,
tiene que hacer el esfuerzo de
and
notificar
may,
ya,
and may
y
immediately notify the
inmediatamente
special magistrate and request a hearing. So in this particular case,
magistrado. En
he
este caso,
contacted the violator,
ella
Yes.
se notificó a ella.
and then the violation was corrected.
La violación fue
Right, which is,
corregida.
because it says may, it doesn't say that he needed to contact you
I'm not disputing that. I'm
Okay.
saying he contacted
Bueno,
the
Yes.
violator,
él lo hizo, él se
and upon
contactó
which
con él,
time the violation was corrected.
y la violación fue
Okay?
finalmente corregida.
So, going back to 21-20, says a hearing, if a finding of a violation or repeat violation has been made as provided in this part, a hearing shall not be necessary
Entonces, una audiencia
for the
no
issuance
es necesario
of the order imposing the fine.
hacer una orden para
It says a fine imposed pursuant to this section shall not exceed $1,000 per day
entonces podría pedir
for a first
por
violation,
día por la primera violación.
and shall not exceed $5,000 per day for a repeat violation.
$5,000 por día por una
So,
violación repetida.
what we do know
Entonces lo que sabemos
is that there was no previous order
hubo una orden previa
for which non-compliance was at issue,
por la que se habría
correct?
una multa por no cumplir,
Correct.
¿verdad?
okay?
Correcto.
And we know that there's no repeat violation pursuant to the criterion used
Una
to,
violación repetida no existe.
there was no repeat violation as relates to this particular citation.
Relación
Yes.
con esta
Okay.
violación.
We're going under that second section.
So,
Entonces,
it then says, for which you've kindly highlighted for me,
luego,
Not for you, Judge, those
Okay.
were my notes. I
Okay.
apologize.
uh,
Do not want to improperly mislead
No.
you.
if the special magistrate finds the violation to be irreparable
magistrado
or irreversible in nature,
ha sido
it may impose a fine not to exceed $5,000 per violation. Okay. In determining the amount of the fine, if any, the special magistrate shall consider the following factors: the gravity of the violation, any action taken by the violator to correct the violation, and any previous violations committed by the violator.
There's two portions.
The special magistrate may also reduce the fine imposed pursuant to this section.
And just to correct, that says up to 15,000, not 5,000. At the, in that section.
If the special magistrate finds a violation to be irreparable or irreversible, it may oppose a fine not to exceed $15,000 per violation.
Yes.
That's what it says.
That's correct. And what we're saying is because she got, the violation was under 5-32, which is,
It was under 5-29.
well,
C.
that's, the original violation that she received that Your Honor has up there is under 5-32, which is installing the fence without a permit. So what we're saying is that you can't go back and fix the damage that was done. Her fixing and actually getting a permit and putting that fence up does not change the fact that that gas line was ruptured because of that. So in essence, because Your Honor's saying, you know, it was fixed after the fact, so it wasn't irreparable or reversible, it's not the actual gas leak that was the violation. The violation was her installing that fence without a permit.
It would have had to be the gas leak that was the violation.
No, Judge, the violation is under 5-32, which is her installing that fence without a permit. So her fixing that,
So you cannot possibly be suggesting to the court that a violation of 5-32 is a $15,000 fine. And
Judge, if Your Honor would like to continue and watch the body-worn camera, Your Honor will understand why this is such a big deal to the city.
Because it led to another violation, a different violation, 5-29C. That's what this video is about. This video is about the fact that 5-32 led to 5-29C.
Yes, and she can't go back and fix the damage that was already done, and that's why we're saying that this was an irreversible act, a single irreversible act. And fixing the fence doesn't correct that violation.
No, a separate remedial act fixed that violation. Florida City went and fixed that violation.
Correct.
Now, the
It
city,
wasn't the
now, if
homeowner.
the city gets an invoice from Florida City, pursuant to these sections, the city is entitled to have the homeowner compensate them for that invoice. And as for a fine, I find that this was a singular event. It's not a repeat violation. It's a singular event. And pursuant to 21-20,
Is Your Honor about to rule?
yes.
Can Your Honor please watch the body-worn camera before you do?
Tell me, how is you watching the body cam? You're gonna
Because
show
there's-
me. The body cam is gonna show me that this was a serious incident, right? This was
And I don't want Your Honor to take it from my word, but I want Your Honor to take it from the actual
this was the
evidence.
gravity that wants me to see this video in support of the fact that this was a grave event that occurred.
Correct. There's an elementary school
And I have-
down the street.
I have
There's
no-
neighbors that were walking around.
I have no doubt that a ruptured gas line is a grave event.
So is Your Honor going to be watching the body-worn camera?
I am not going to watch the body-worn
Okay,
camera
thank
because
you.
I don't believe that the body-worn camera.
So Your Honor's not going to be
is-
taking that as substantial competent evidence?
The magistrate finds that the violation of 5-29 caused a grave event.
So Your Honor does find that the body-worn camera that you haven't watched is competent evidence?
I'm going to find that the testimony as to the fact that there was a ruptured gas line in and of itself is competent evidence for me to determine that a grave violation occurred.
But there was no testimony presented by the officer, Mr. Perez.
Yes, who
The testimony has been coming from me as I've been trying to summarize
right.
the events for you, but I want
All
Your
right.
Honor to see it yourself and actually take the evidence for what it's worth before you rule.
All right.
Thank you.
How long is this going to be? 'Cause
Judge,
I'm
I've
about
shortened,
to skip all this riding around.
I've shortened it for you. It's actually a lot longer. That first video is up until 11 minutes and 32 seconds.
Wha-
And
Why
the
can't I
third,
just skip to when they get to the property? Why I gotta watch the driving?
if I may I approach?
Sure. I mean, I could do it. I'm a little tech savvy. Wait a minute. Because you explained to me that we haven't had testimony yet.
Yes.
All right, so let's get some testimony
Okay.
to lay the foundation for the video and all of that stuff.
Sure. In that case, can I please get the, I have to unset it up for you so I can enter into evidence through Officer Perez.
All right.
Thank you.
The Haitian translator? Yes. The other translator, you're free to go.
I'll put it in through Officer Perez. Officer Dresham had to go to court, so she stepped out. Now, would Your Honor like to do a full-blown director just to enter the BWC into evidence for Your Honor portion?
No, make your case, counsel.
Okay. The city would like to call Officer Jose Perez. Sir, can you please state your name for the record?
Yes, my name is Jose Perez.
And can you please tell the court what is your position?
I am a code enforcement officer for the city of North Miami.
And did you come into contact with the property located at 12155 North Miami Avenue, North Miami, Florida 33168 on February 5th, 2019?
Yes,
How did you come in contact with this property?
I was dispatched out. The call came in from the police dispatch, and they sent me to the scene.
And who was present at the scene when you arrived?
When I arrived, Officer Pinky was at the scene, along with other officers, as well as Officer Antoine.
And can you advise of the court of whether there were people in the area other than the officers?
Correct, there were bystanders that were being told to stay away from the area.
Now, did the officers have to block off the street?
Yes,
Okay. Now, did you have an opportunity to walk around the property?
yes, I walked around the property after the fire department cleared it.
And can you explain, was there an actual drilling device back there?
Yes,
And what did this drilling device look like?
it appeared to be a commercial-sized drill. The drill bit piece itself was approximately maybe 5 feet, 6 feet in height, and width-wise, it was probably a little bit skinnier than I am.
Let me
Now-
take you back for a moment and ask. You were asked, did you look around the property? You said once the fire department cleared it.
Yes.
Can you give clarification as to what do you mean the fire department cleared it?
So once the fire department was dispatched and they arrived, they did not let anyone in the property due to the severity of the gas leak itself. They wore their full outfits with their breathing mask because of the severity of the gas leak itself, and they were not allowing anyone onto the property.
And so when they cleared it, did they clear it because the threat of harm had ceased?
Negative. They clamped it down temporarily, seizing most of the leak while it still leaked, and they let us in because the leak had been reduced.
And Judge, may I approach for the photographs that you have still? Thank you.
So in reducing the gas, they found that it was the threat of harm had been reduced enough to allow individuals to walk around the premises.
Reduced enough to be escorted by the fire department and the police officer Pinky, into the rear to take photographs.
Did the police officer have on any special breathing?
Negative.